Mr. Julian Butler, who is a shareholder at Sorority. He works up in the Huntsville office. He earned his bachelor's and his LLB. Remember those? Remember LLBs? He earned his bachelor's and LLB from the University of Alabama. And he is active in democratic politics on the local, state, and national levels. He is a trustee of the Alabama Department of Archives and History, in which we sit today. He is also a board member of the Alabama Humanities Foundation, which has generously funded this event. He's former president of the Arts Council. He's worked on statewide campaigns and local campaigns. He has been recognized by numerous organizations, both civic and professional, and it is my honor to introduce to you today Mr. Julian Butler. Thank you, Mr. Butler.
Good afternoon. We're really going from the law to history a little bit. We're going to talk, first of all, when you talk about a crazy juxtaposition, I'm going to talk about how the path to statehood, and then I'm going to make some comments about reform efforts on the 1901 Constitution. I want to stress to you, during the course of my talk, I will express some opinions. Those are not the opinions of the Jones Law School, of Faulkner University, or of the Department of Archives and History, my law firm, or even my wife who is here. They're mine and mine alone. Alabama's path to statehood really began in April of 1798. The Mississippi Territory was created by Congress, and the Mississippi Territory was everything west of Georgia to the Mississippi River. It encompassed what is now the state of Alabama and the state of Mississippi, with the territorial capital at Natchez. The exact eastern boundary, although it could be described, it had never really been laid out. The Creek Indians occupied most of that territory, and they did not look with much pleasure on surveyors coming through and surveying the land. The Mississippi Territorial Legislature created 7 counties in what is now the state of Alabama. In 1800, it created Washington County, county seat of Chatham, with the name for President George Washington. In 1808, it created Madison County, named for President James Madison, with the county seat of Huntsville. Madison actually had not taken office as president, but had been elected and was very popular. In 1809, Baldwin County, named for Senator Abraham Baldwin of Georgia, with the county seat at Bay Minette. 1812, Clark County, county seat Grove Hill, named for Senator General John Clark of Georgia. 1812, Mobile County, named for the Mobilia Indians. 1815, Monroe County, with the county seat at Monroeville, named for President James Monroe. And in 1816, Montgomery County. And in preparing this, I learned something, and I'll bet a lot of you people that live in Montgomery don't necessarily know this. Montgomery County and Montgomery City are named for 2 different people. Montgomery County is named for Major L.P. Montgomery, who fought with Andrew Jackson and was killed at Horseshoe Bend. Montgomery City is named for Richard Montgomery, who was a hero of the Revolution. But those were the 7 counties of that is in what is now Alabama that were created by the Mississippi Territorial Legislature. In 1811, an act was passed incorporating the city of Huntsville, again by the Mississippi Territorial Legislature. First incorporated city in what is now Alabama. March 1817, Mississippi becomes a state. And in August, Alabama became a territory. And basically, Alabama as we know it today became the Alabama Territory. with its capital at St. Stephen's in Washington County. The Alabama Territorial Legislature created an additional 15 counties between August of 1817 and the Constitutional Convention in July 1819. They were Autauga, what we know as Bibb, that was Cahaba County, Blount, Conecuh, Morgan, which was then known as Catawba County, Dallas, Franklin, Lauderdale, Lawrence, Limestone, Marengo, St. Clair, Shelby, and Tuscaloosa. And that's how those were the 22 counties of the Alabama Territory at the time of statehood. And that is the map. And if you will notice, one of the interesting things is the 6 Tennessee Valley counties. The boundaries are basically what they are today. Small, but that's what they are. But you then start down the rest of the state, and the counties are much, much larger. Those counties, while a county remains with that name, they've been divided and subdivided and redivided to come up with the 67 counties that we have today. In 1819, on February the 19th, Congress passed the enabling legislation for Alabama to begin the steps to becoming a state. Senator Charles Tate of Georgia was really Alabama's patron in Congress. Interestingly, Tate did not stand for re-election, and the Enabling Act was passed 2 days before he left Congress. President Monroe signed it on March 2nd, 1819. The act specified that residents of the Alabama Territory were to write a constitution and present it to Congress for approval. The act contained the provision, said territory, when formed into a state, shall be admitted into the Union upon the same footing as the original states. And as I began the events of 1819, I hope you will focus on a timeline, and that we started on February 19th and compare it to the timeline for anything to happen in the Alabama Legislature or the United States Congress today. And you add to that the lack of communication and the lack of transportation at the time. Elections for the Constitutional Convention were held the first Monday and Tuesday in May of 1819. And then something very interesting happened. On June 1st, 1819, President James Monroe appears in Huntsville, unannounced, unexpected. Monroe was on a tour of Southern fortifications. He had done the same when he first became president and toured the fortifications in what was then known as the Northwest. We're talking about Pennsylvania and Ohio, that area. He decides to do the same in the South. He comes across Georgia, goes up to Chattanooga, and comes down to Huntsville. Literally, the President of the United States and 2 other horsemen come riding in on horseback to the town square, and nobody knew they were coming. As you can imagine, a crowd soon gathered, and they decided that they would have a banquet to honor him the following night. They did. We have a record of that banquet, including the toasts that were made. There were 22 toasts that were made that night. The condition of the participants in the banquet at the end of it is not recorded in history. But there are those that would say that visit into Alabama prompted Monroe's interest in Alabama and prompted Monroe's interest in Alabama becoming a state. On July 5th, 1819, 44 delegates from the 22 counties assembled in Huntsville. The Congressional Act stipulated that The convention would be held in Huntsville, which was the largest city in Alabama at the time. Madison County, the largest county in Alabama. Madison County somewhat dominated that convention. It had 8 delegates. Monroe County had 4. Blount and Limestone had 3, and the remaining counties had 1 or 2. John Williams Walker of Huntsville was elected as the president, and the critical committee assignment, that of drafting a constitution, went to Clement Comer Clay. John Williams Walker was a Huntsville lawyer. Clement C. Clay was a Huntsville lawyer. If you go to Huntsville or have been, there's a half block off the square in downtown Huntsville, which is a reconstruction of the half block as it stood in 1819 with the building in which the delegates met. It was a carpenter shop at the time, a 2-story building. It was used for dances and other purposes, probably the largest building in town. And that's where the 44 delegates met. The delegates, there were 18 lawyers, 4 doctors, 2 ministers, a surveyor, a merchant, and 4 planners. The balance likely being small farmers or tradesmen. 9 of the 44 delegates had prior legislative or judicial experience in the states from which they had come. 7 had served in the Alabama Territorial Legislature. 3 had served in Congress from other states. At least 8 of the men had some college training. The potential ability of the delegates is best indicated by the fact that from them the state obtained 6 governors, 6 judges of the Supreme Court, and 6 United States senators. To say it was a distinguished gathering of Alabamians is an understatement. Now, I want to be clear about it. They were all white men. There were no women, and there were no African Americans. Interestingly, and it may explain some of the problems of Alabama's 6 constitutions, no woman has ever participated as a member of any of the 6 constitutional conventions. Women could not vote at any time that the 6 constitutions were drafted. The known birthplaces, and this is interesting, few, if any, of the men in Huntsville in 1819 were born in what is now the state of Alabama. 15 were from Virginia, 5 from North Carolina, 2 from South Carolina, 2 from Georgia, 1 each from England, Vermont, Delaware, and Pennsylvania. The birthplace of the remainder are not known. A committee of 15 was charged with drafting a constitution. The convention began on July 5th. The committee reported out on July 15th. Again, can you imagine writing a state constitution in 10 days? The convention in total was in session for less than a month. All 44 delegates signed the Constitution on August 2nd. To say the Constitution was in session less than a month. And again, can you imagine any legislative body at any level in the United States today where you had unanimity that all 44 would have signed the Constitution? A copy was transmitted to Congress. It was not submitted to the people of Alabama for a vote. The Congress passed a resolution of admission on December 6th, and Alabama became a state on December 14th when President Monroe signed the proclamation. From start to finish, from the passage of the Enabling Act by Congress until Monroe signed Alabama in the Union, 10 months. The Constitution was the most liberal state constitution of the 22 states of the United States at the time. Now, when is the last time you heard most liberal in Alabama mentioned in the same sentence? But it was. Interestingly, we were the 21st 21st state. And I said 22, we were the 21st. As we began the celebration of the bicentennial, we began looking for a 21-star flag. What did the flag look like when Alabama became a state? There's not one. And I'm going to give you the trivia answer that you can defeat everybody that you're ever in a trivia contest with. When do you add stars to the United States flag? Only on the 4th of July. Illinois had become a state, and on July 4th, 1819, you had a 20-star flag. Alabama comes in December. In January, Maine comes in. So the next July 4th, there was a 22-star flag. We did a lot of searching for the 21-star flag and never found it. One of the most liberal aspects of the Constitution, it provided that every white male 21 years of age and a citizen of the U.S. who has been in the state 1 year and the district 3 months was eligible to vote. Now again, you say, wait a minute, there's nothing liberal about that. Yes, there is. There was no requirement that a person, a white male, own property in order to vote or had served in the militia. Of the southern states, only Kentucky had a similar provision. Apportionment. And again, I probably learned it at some point, but as I began studying this, it shocked me. The United States Constitution provided at the time that in determining apportionment, determining population and therefore apportionment, you counted a slave as 3/5 of a white man. And that was fairly common in other state constitutions. The committee that drafted the Alabama Constitution brought that recommendation out, that Alabama used the U.S. constitutional formula. The convention overruled the committee and adopted that in determining population and therefore apportionment, a slave counted the same as a white man. Now, that said, there was a reason for it. And it was somewhat a compromise between the hill country of North Alabama and the South Alabama counties, that by counting slaves as a full person in determining population and then apportionment, it favored the counties of the Black Belt that had large slave populations. The Constitution required that the state be reapportioned in 1820, 1823, and 1826, 3 years apart. And that was in large part due to the rapid growth of the state of Alabama, and to have the apportionment of the legislature reflect the population, you had to count it very frequently. And they went on every 6 years thereafter. The first legislative session of the Alabama legislature was to meet in Huntsville, and all subsequent sessions in Cahaba in Dallas County, when the legislature was to revisit in 1825, only 6 years later, that decision. Ultimately, the capital was moved to Tuscaloosa, where some of it believe still is the capital of the state of Alabama, and then was moved to Montgomery in the 1850s. Cahaba, one of the larger reasons that Cahaba was selected, William Wyatt Bibb was the governor of the Alabama Territory and was first governor of Alabama. His plantation was in Autauga County, and he favored having the state capital somewhere closer to where he was. The 1819 Constitution provided that the Alabama Assembly, the name of the legislature, would convene in Huntsville on October 25th, 1819. always been curious to me. First session of the Alabama Legislature met before Alabama was a state. Now, you explain the legality of anything they did, but I don't think it was ever challenged. The Huntsville session of the Alabama Assembly was one of the most vital and interesting in the history of the state, writers say. This was the real beginning of Alabama's functioning as an equal state under the federal Constitution. United States senators were chosen, a Supreme Court selected, and precedents for the unknown future were instituted. This famous First Assembly convened on October 25th and adjourned December 17th, 1819, 3 days after Alabama became a state. And there's some question as to how many members were still there on the 17th when it adjourned. A lot of thought is Christmas was coming, it was a long way home, and a lot of them were already on the road. One of the writers wrote this, that it adjourned in time for members who lived at great distances from Huntsville to reach their homes in time for Christmas, if they did not linger too long at wayside taverns. And I know to those of y'all that live in Montgomery particularly, the idea of an Alabama legislator lingering at a wayside tavern is just unthinkable. That really is the story of how Alabama became a state. And as I say, you take away from it 2 or 3 things. One, that in a time when there was no good communication and no good transportation, a system worked. In 10 months' time, you went from ground zero to statehood. And second, it reflects the Jacksonian, Jeffersonian principles, really more Jacksonian, that were very popular in Alabama at the time. And that made the Constitution a very liberal document. It has been said that from 1819 to 1901, we went from the most liberal Constitution in the United States to the most reactionary Constitution in the United States. As I say, I'm going to give some opinions, and they're mine and mine alone. With that, I would like to move on to the second subject I was asked to talk about, and that's efforts to reform the 1901 Constitution. I know that y'all have gone through the exhibit, and I'm sure Scotty talked to you about it. Alabama has had 6 constitutions, drafted between 1819 and 1901. You had 1819, 1961, 1861, 1865, 1868, 1875, and then 1901. As you study those constitutions, you look at 1819 was when we became a state. 1861 is when we had withdrawn from the Union and we were no longer a state of the United States of America. So the Constitution had to be redone. 1865, we were whooped and we're trying to get back in the Union. So we were no longer a state of the Confederate States of America. 1868 was the Reconstruction Constitution. And you had the Freedmen's Bureau, you had federal troops in Alabama, you had a large number of the formerly enslaved people were voting. They were a large number of formerly enslaved people were delegates to that 1868 convention, and it provided very liberal voting policies. 1875, the federal troops were gone from Alabama, the Freedmen's Bureau was gone from Alabama, and you had the former Confederates had regained control, but there was no attempt to restrict black voting in the 1875 Constitution. There were still federal troops in some former Confederate states. There was a fear if they did that, you would bring the federal troops back to Alabama. You had the Populace Revolt during the 1890s, which was a coalition of mainly small yeoman farmers, labor union members in the industrial areas around Birmingham, and black voters. And it put a great fear in many of the white voters of Alabama. And so you had the 1901 Constitution called for the express purpose of disenfranchising blacks and poor people. And since 1901, we have been struggling with that Constitution. You have, over the years, you've had many governors seek constitutional reform. Governor Emmett O'Neill, who was governor from 1911 to 1915, was a member of the 1901 Constitutional Convention. But he noted in 1914 that little consideration was given to matters of reform. He concluded that Alabama was having to operate with a constitution that was framed to meet conditions which can never again exist. And following O'Neill, Governor Thomas Kilby, 1919-1923, Big Jim Folsom, 1947 to 51 and 55 to 59, Albert Brewer, May of 68 to 1971, Fob James, 79 to 83 and 95 to 99, Don Siegelman, 99 to 2003, and Bob Riley, 2003 to 2011. All were advocates of constitutional reform. You will note conspicuously absent from that list are the last two governors of Alabama. There has been no real call for constitutional reform. If you think back to 2018, can you name a single candidate that you encountered, whether for governor, lieutenant governor, attorney general, the Alabama legislature, who said, one of my main concerns is constitutional reform. I want Alabama to have a new constitution. The Alabama Constitution in 1901 came under immediate attack. A man named Jackson W. Giles, an African-American postman in Montgomery, filed suit in September of 1902. The suit alleged that the whole registration scheme of the Alabama Constitution is a fraud upon the Constitution of the United States, and asked the court to declare it void. A district court in Montgomery ruled, dismissed the suit for want of jurisdiction. I've struggled to understand that and have yet to been able to. And the United States Supreme Court upheld that decision. Remember, this would have been basically the same Supreme Court that determined Plessy versus Ferguson, that separate but equal were constitutional. You had no real movement on constitutional reform until the 70s. The Alabama had a constitutional commission was created from 1970, and it functioned through 1973. Its final report found that the 1901 Constitution was defective, recommended adoption of a new Constitution. First time Alabama had used a constitutional commission. Nothing substantive really came out of that. You had then the judicial article, the most significant piece of reform of the Alabama Constitution. There are members or defenders of the Constitutional Commission that say, oh, it came out of the Constitutional Commission. It did not. There were two statewide conferences sponsored by the American Judicial Society that brought about the movement for the judicial article. Howell Heflin became Chief Justice of the Alabama Supreme Court in 1971, and Heflin was the great pusher of the judicial article, which completely rewrote that section of the Alabama Constitution on the judiciary. It was approved by voters in December of 1973. Possibly the greatest failure. The legislature in 1983 passed a new constitution. Governor Fob James in 78 had campaigned on the need for a new constitution, and he was out of office, but the legislature passed a constitution. A lawsuit was filed, State versus Manley, seeking to enjoin the vote on the new Constitution on November 8th. The Supreme Court blocked the election, and it held that the legislature could not adopt an entire new Constitution and submit it to the voters for ratification. It said there are only two ways to change the Alabama Constitution. The legislature can call a constitutional convention, submit that question to the voters. If they vote to have the convention, a convention can be held to propose, again to go back to the voters, a new constitution. Or the legislature can amend the Constitution article by article, but cannot adopt an entire new constitution. I've read the opinion. I challenge you to. I do not understand that logic. You can do it article by article, but cannot do it on the whole. And that put a real halt to a lot of constitutional reform movements. Governor Bob Riley used his first executive order after taking office to form the Alabama Citizens Constitutional Commission. Not a lot came out of that. In 2011, the legislature created the Constitutional Revision Commission. The first report was January 2014. In creating that revision commission, the legislature provided, but you cannot deal with taxing questions. So before it started, one of the critical needs in constitutional reform were pulled out from under. The revision commission, chaired by former Governor Albert Brewer, proposed 6 amendments, which were passed. One on banks and banking in November of 2012, and one on corporations in November 2012. The banks and banking article was proposed by the banking industry. The corporations was proposed mainly by lawyers who do corporations work. You then had 4 minor amendments adopted on November 8th, 2016. One had to do with local constitutional amendments. The second was county administrative power. And there were those that touted, oh, wow, we're going to give the counties home rule. But it included the provision that it expressly prohibited the exercising of police, land use, and taxing powers through that amendment, which gutted anything a county really needs to do. To use, and I think it was John Nance Garner talked about something being a warmed over bucket of spit. Well, that was a warmed over bucket of spit, excuse me. One had to do with the distribution of powers in state government. And again, it's somewhat humorous that you would have a constitutional revision commission and it submit an amendment to Alabama, to the voters, that instead of having three branches of, that now we have three branches of government rather than three departments of government. That's the minutia to which the Alabama Constitution has lowered itself. And the last one was on impeachment. It was non-substantive technical changes. So you look at the over 100 years that we've had the Constitution of 1901, other than the judicial article, there's not been any real progress made. Some of the things that are interesting, the poll tax, which was the chief provision of the 1901 Constitution to restrict poor people and African Americans, many of whom were poor, from voting, was the cumulative poll tax. And I may be the only person in this room that ever paid a poll tax. Most of you are a lot younger than I am. Poll tax was $2 a year, but it was cumulative. If you missed a year, then the next year you had to pay $4. And you register to vote when you're 41 years old. You were 21 was the voting age then. You had to pay 20 years of poll tax, $40. And that was very restrictive. Alabama didn't do away with the poll tax. The 24th Amendment to the United States Constitution in 1964 outlawed the poll tax. In for qualification to vote in federal elections. And then a 3-judge federal court in 1966 held the poll tax was unconstitutional for voting in the state of Alabama. You've heard a lot about the racist language. The specific provision of the Constitution is Section 256, amended by Section 111, quote, to avoid confusion and disorder and to promote effective and economical planning for education, the legislature may authorize the parents or guardians of minors who desire that such minors shall attend schools provided for their own race to make election to that end, and such election to be effective for such period and to such extent as the legislature may provide. Amendments to remove that were defeated by voters in 2004 and 2012. There's a new provision that will be on the ballot next year that will read, the legislature, upon the recommendation of the director of the Legislative Services Agency, through a proposed draft, may arrange this Constitution as amended in proper articles, parts, and sections, removing all racist language. So they're trying a end run, really, to try to get the racist language out. There has been an organization in Alabama, the Alabama Citizens for Constitutional Reform. I served for a period of time on the board of that organization. It championed the cause of calling a constitutional convention for Alabama to have a new constitution. Sadly, although the organization still exists, it has not been very active lately. The question, when I talk on constitutional reform, I am frequently asked, do you believe that we will have a new constitution? Now, I realize I'm an old man, but it ain't going to happen in my lifetime. And I really don't see it in the immediate future. I believe if we are to have a new constitution in the state of Alabama, which is criminally needed, not only is the Alabama Constitution the longest in the United States, they are those that say it's the longest constitution in the world. But I think if we are to have a new constitution, it will take a popular governor in their second term, when they're not going to run for re-election, and that they bet the farm on having a constitutional convention, that they use all the powers of the governor's office to persuade the legislature to submit to the people and the people to vote to hold a constitutional convention. I regret that I'm that pessimistic, but I'm afraid I'm that realistic. If I offended any of you with my opinions, I apologize to you, and as I said, they're mine and mine alone. We've got about 5 minutes or so. Questions? Yes, ma'am.
This might not be a fair question, but this map has been puzzling me all morning. Do you know what's going on with those small swatches of land around Dallas, Montgomery, and Monroe that seem to be disconnected from another county?
I did not prepare the map,
Okay.
so I don't know. Okay, up. Now the part beside Marengo and the part in eastern Alabama that are not in counties were Indian territory, and they were part of the Alabama territory, but they were not a county. They were just Indian territory.
Thank you.
Yes, sir.
When it comes to the 3/5 rule, I was interested in that because originally that was proposed at the federal level as a compromise, and it was actually the non-slave holding states that wanted them to be counted as zero.
Right.
It's the slave holding states that wanted to be counted as a whole. So I'm just kind of curious, why didn't Alabama at its inception just count them as a full person?
They did count him as a full person.
Oh, I guess I misunderstood. I thought you said they only counted as 3/5 like the federal.
No. When the committee proposed that, and the convention voted it down, and Alabama counted him as a full person.
Zero.
Huh?
It counted them as zero. The Constitution of 1819 provided for the white basis. Counted no slaves at all. Counted only free white persons.
I beg to differ with you. You may know more than I do, but that's not what I read. Yes, sir.
You mentioned that the only major reform since 01 was the judicial article. And there's been a lot of talk about how bad the voting provisions were, the suffrage provisions in Article 8. Did you say, or did I miss it, that Article 8 was repealed by the voters of the state in the 90s and replaced with a non-discriminatory suffrage provision?
No. It's all the non-discriminatory suffrage provision have all come about either through federal legislation or through federal court decision.
Well, I guess we'll make it different.
Okay.
I think it's 1996 that the voters completely revised Article 8 on suffrage in elections, and to their credit, and they eliminated all these arcane, silly rules involving empowering registrars and so forth, and it's a remarkable provision. I wanted to also ask you if you, as a part of the reforms that might be needed, think there should be any reform of the principle of separation of powers in the allocation of power between the three departments of government.
I really don't have an opinion on that. I don't. And I'll be honest, I've never really focused on that question. That's certainly a question we're being asked to decide on the federal level now and have varying opinions. I've never heard that as a real discussion in Alabama.
Mr. Butler, if that governor was able to call that convention, what 5 major groups would he have to put together? Landowners, public education, labor. What groups control how a convention would act?
You can answer that better than I can. I can call the roll. You walk outside this building and you start in a circle at each of the organizations that lobby the Alabama legislature. And the larger and prettier the building, the more influence they're going to have. And that's one of the fears of advocates of a constitutional convention, that the groups that have dominated the Alabama legislature would dominate the constitutional convention, and we might not really have a reformed constitution. Any other questions? Thank you very much.
Thank you, Mr. Butler. Our next session begins at 2:15, so there is a break until 2:15, and then we'll meet back in here then. Thank you very much.
Yeah.